Although the court granted our motion to compel Mr. Cosby to appear for a second deposition as testimony under oath in this civil case, the court also indicated that his appearance for the deposition would be stayed until such time as the criminal case concluded, which made sense because otherwise it was likely that he would invoke his Fifth Amendment privilege against self-incrimination, which he would have every right to do, and would not testify information in that second deposition. He did provide answers to the first deposition, but he did make a motion to compel him to appear for a second deposition, and filed brief. They objected to that, but we prevailed. So, in other words, the September date is to see whether, in fact, a second criminal trial will be commenced, and then to reevaluate the stay on Mr. Cosby's deposition and stay on any other discovery in our case until we see what the status of that second criminal case is. So we're very happy about that. So we'll be returning on September 14th for a reevaluation of that stay. We are committed to taking Mr. Cosby's second deposition, but given that he declined to testify in that first criminal case and asserted his Fifth Amendment privilege, it's likely that he will do so in this case. So we'll be back on September 14th. I'd be happy to answer any questions about that. We have vigorously litigated the civil case. We still have some more to do. And we'll be looking forward to the trial next July. Anything about this, and then I'll talk about his so-called sexual assault, speaking to it.
Yeah, what do you think about this town hall that he's planning to do for spokespeople?
Well, according to his spokesperson, and Camille Cosby's spokesperson, Mr. Cosby had been indicating that he was going to do a speaking tour this summer, so-called town halls, in which he would be speaking in Birmingham and Detroit, Chicago, and other cities. And the suggestion appeared to be that he would be talking about sexual assault, what it is, how to avoid false allegations of sexual assault, and other reports. And his defense team approved of that. Now, I don't know if those reports are true or not. Ms. Arusa is now walking all of that back. It was not surprising that he got a lot of bad press over that. Cosby's spokesperson seemed to indicate that that there was a suggestion that somehow people should know that a brush on the shoulder could be sexual assault, which is patently ridiculous. No such criminal case would ever be filed on that, so that may have been an attempt to minimize the true meaning of sexual assault. In the criminal case, the allegation is drugging and incapacitating a woman and then sexually assaulting her after she is not able to resist on account of the drugs she has been provided. So that is so far from a tap on the shoulder that it's not even the same realm of discussion. I'll just say this. If Mr. Cosby decides to proceed with his so-called town halls, I am going to consider a parallel speaking tour. And in those cities, I will consider discussing what sexual assault really is and what the law permits and requires in order to charge someone with drugging or incapacitating a woman or a man and then sexually assaulting. What a criminal case requires in order for someone to be charged, and the rights of a person who alleged she was a victim to also file a civil lawsuit. Actually, that issue is a huge issue, particularly for young women, not just those who accuse Mr. Cosby of drugging and or intoxicating them or incapacitating them in some form and then sexually assaulting, but for many, many women throughout this country, as we saw in the Darren Sharkey case, where he did enter a plea and is now in prison for drugging and incapacitating women. And I represent 3 victims there.
Is your client willing and ready to testify in that trial?
Yes. My client has given a deposition in the civil lawsuit. And she is ready, willing, and able to proceed with the trial if as and when that happens.
How did the verdict, the non-verdict in the Pennsylvania case affect your case?
There wasn't a verdict in the Pennsylvania criminal case because the verdict would have required a unanimous decision by the jury, either for conviction or for acquittal. There was no unanimous decision. There was a deadline.
And how do you?
And we don't know the exact split. The various reports, however, it was not unanimous. That's clear. And so then it was for the prosecutor to decide whether or not he wished to exercise his discretion to refile. He immediately indicated yes, he was going to refile this case. He said the people of Pennsylvania are entitled to a verdict, and that's what he's going to do. We expect that to occur very soon, potentially within 120 days. One of my clients, one of the many, many accusers of Mr. Cosby, who testified at the trial, that's Kelly Johnson, a very brave young woman. And her mother also testified. And if as and when there's another trial, if she is subpoenaed as though she would be concluded, she will directly with the prosecution. In reference to other accusers, I do think that it's important that other accusers be permitted to testify. The defense has vigorously opposed the testimony being admitted of any other accuser, of any accuser whatsoever. They wanted 0 accusers other than Ms. Constant to be permitted to testify. The prosecution in the last case asked the court to, in a motion, to permit it to call 13 accusers. However, the court only allowed 1 accuser, Ms. Johnson, to testify other than Ms. Constant. I hope that the court will, that the prosecutor will renew his motion to allow other accusers to testify. It is the same judge. We don't know whether or not he will grant that motion. I do hope that the court will state and ask, and that the prosecutor will ask him to state the reasons why he declined to allow other accusers to testify. He has not stated his reasons as to why he would not allow the other 12 that the prosecution sought to testify, nor has he stated why he did allow Ms. Johnson to testify. So I think it would be important for the court to put his reasons on the record.
Will you ask for other accusers to be able to testify in this case? Is that already been
Oh,
indicated,
in
or-
this case, yes, we definitely are interested in the testimony of other accusers at the trial, and actually we have already taken the deposition of some other accusers in our civil case, but we are not going to state their names, nor are we going to disclose what they testified to under oath. But yes, we have done that, and we will seek to do that at the trial.
Has it been litigated yet or argued yet whether that would be admissible in trial, or is that to be figured out prior to trial?
There is discretion in California to allow that, and we think that'll be very important in our civil case. And regardless of the decision of the court in reference to other accusers in the criminal case, we're proceeding under California law, and that will be important as far as we are concerned for our case.
One of the
If you were
jurors.
to stage these counter town halls, would you bring forward some of the accusers of those?
question is if I engage in a counter town hall or town hall of my own, would other accused attend? I don't know. I know that there are many, many accused who are very, very upset with the suggestion that was made by Mr. Cosby's representative and Ms. Cosby's representative, Laura Cosby's representative. There would be town halls. And I stated at the time that I felt that it might be a defense tactic to try to influence or to contaminate the jury with the suggestion that false allegations may be made against him, and the insinuation would be then that people might draw against Mr. Cosby. And I don't think that that's appropriate for him to try to have an impact on the second jury pool. I don't know that that was his intention. However, I can't rule it out. All I can say is, Mr. Cosby, be careful what you wish for, because if you go on that tour, I will be there. I was there when he did his far from finished comedy tour in Atlanta, Georgia. At that point, I was barred from going in, even though I had a ticket. I filed a lawsuit against the Cobb Energy Center for not permitting me to go in because I was on a list apparently forwarded by Mr. Cosby's representatives, and I was successful with that lawsuit. Where other consent decree never to allow a performer in the future to decide who can or cannot come into his performances. So anyway, having said that, we'll have to wait to see if Mr. Cosby now rethinks his town hall. Some of his supporters in the past have indicated he's too old and too feeble to appear for a second trial or even to have stood trial at the first point. At the same time, he appears to say he wants to return to his tour, either a comedy tour or his sexual assault tour. So I think if he can stand up on the stage and perform, he can sit down in the courtroom in a criminal case and be tried on 3 felony charges of aggravated indecent assault. Less is required of him in a criminal courtroom. All he has to do is show up and sit down and listen.
One of the jurors in Pennsylvania said one of the things that came into question was it took her so long to go to the police. It's taken your client a very long time for this to happen. Is that a new consideration now?
In Pennsylvania, there's a 12-year statute of limitations, 12 years, during which a prosecutor may file a criminal case alleging sexual assault, aggravated indecent assault. The prosecutor was within the 12-year period statute of limitations filed. Actually, in Allred Constance situation, and I was at the criminal trial, she reported, she alleges, within a year of the incident which she alleges occurred. In our case in California, the law allows an adult survivor of child sexual abuse a longer period of time in which to file a civil lawsuit. It does not require that an alleged victim go to the police. However, Ms. Huth did go to the police, was interviewed by 2 detectives from the Special Victims Unit, approximately 45 minutes. And she went there with me because Jack at the time had indicated publicly that he would invite any person who alleges that she was the victim of a crime by Mr. Cosby or anyone else to come in and report it, even if it would be too late to prosecute. And she did that. We knew that it would be too late under the criminal statute of limitations then existing for a criminal case to be filed and prosecuted, and District Attorney Jackie Lacey did indicate that a few weeks later. However, she went back and said he wanted to know what's going on. So, we did that. There's a different statute of limitations for a civil case. And Ms. Huth filed the civil case, we allege, timely. Because in California, it's within 3 years of the date of the discovery that the injury was caused by child sexual abuse. And we allege that that's what happened. Not within 3 years of an individual knowing that they were sexually abused as a child, but within 3 years of discovering that your injuries were caused by child sexual abuse. I'm not going to state what Ms. Huth's injuries are that we allege, but I'll just give examples of what could happen. For example, if a person, let's say, is addicted to drugs and in therapy understands and comes to know that their drug addiction was due to the fact that they were abused as a child. If they just discovered that within the last 2 years, and if there's confirmation of that, it could be that they could file a civil lawsuit. It could be too late to file a criminal lawsuit. A criminal case. One last point on the statute of limitations. I've been very active with some of the Cosby accusers in working to change, eliminate, or lengthen the statute of limitations for criminal cases in a number of states, and we were successful in doing that. In Nevada, we extended it for 10 years, and I was with the governor when we signed it into law. 20 years now for criminal prosecution in Nevada of rape and sexual assault. We extended another 10 years in Colorado with the assistance of some of my clients there, That governor signed against the law. And then in California, we went for what I call the whole enchilada to completely eliminate the statute of limitations for rape and sexual assault in California. And we testified. We wrote an article for the Times that was published in one piece. And I'm very happy to say that Governor Brown did sign it into law. So now there's no statute of limitations in California for criminal prosecution of rape and sexual assault. It's not retroactive. It's not going to cover the Cosby cases. Anything else?
When you come back to discovery in September, are some of those depositions from the other accusers going to be a part of that? I'm just wondering how many you've taken depositions.
When we come back in September, it's to provide the court with an update, a status conference, in reference to what is happening with the criminal case. In other words, the prosecutor in Pennsylvania indicated that he will refile. That hasn't happened yet. I expect that he will be a person of his word and do that. But the court wants us to come back in September to determine if in fact that's happening. And that makes sense. And then we will be in a position to determine when we can proceed with discovery, taking Mr. Cosby's deposition. And at what point we can do that. It's something we really want to do. We think it's important. We're the only case, other than Ivy Constant's case, in which Mr. Cosby has provided his deposition. And we'd like to be able to proceed to that second deposition.
Why do you need a second deposition?
We think it's important for our case. All I can say is we filed the motion to compel. In California, ordinarily we can only have a 1-day, 7-hour deposition. Such as we had with Mr. Cosby. And then if you want a second one, you have to argue to the court, make a motion to compel a second deposition, provide all of the facts and the law as to why you should be permitted to take a second deposition. In other words, it would be our burden. We did that. A very extensive brief with all the reasons. Cannot disclose what was in that brief, because then that would disclose some of his answers, which we're not able to do. And based on what we filed, the court did allow us to take a second deposition. But we have to wait. And that's fine.
Could you just mumble some of that?
I can't state it in any way. As much as I would like to. I am not at liberty to state how many depositions we've taken,
The alleged allegation was at the Playboy Mansion.
Yes.
Can you tell us any witnesses there from that time, or can you tell what?
Yeah, we're not going to disclose anything about the evidence in our case.
When you say that Miss Huth went to the police, you mean after, with you, not
Yeah.
X number of years ago, not
Right,
many years
right.
ago.
She went to the
Just
police.
in the last few years. Before, after
Yes, in the
filed
last
this
few,
suit.
yeah. It was after she filed the lawsuit. She had no attorney. We filed the lawsuit. At some point, she substituted us instead of and in place of the former attorney. We were litigating the case.
Can you talk about Ms. Huth's commitment to this? Let's say there is another hung jury or an acquittal, and also,
Well, I mean, Ms. Huth is committed to this civil case, no matter the result of the criminal case against Mr. Cosby. It is not dependent on the outcome of the criminal case. She's proceeding.
because you want to talk during the criminal trial about that your concepts are being proxy for all of the women. Do you guys feel that at all? Like, especially if there is still a hung jury, she's sort of the next one, the next batter up.
I mean, I don't have any statement in reference to Judy. She's not made any statement whatsoever during the entire course of this civil case, and that's the way it's going to continue to be until such time as she testifies on the Wednesday. So let's see. We do have an interest in the outcome of the criminal case, which is why I was there. We'll wait and see. Anything else? Thank you very much. Oh, I'm sorry, this is my partner. Just a second. John West, she's got a fantastic job. All right. Thank you.